How is a narcissist exposed in a court of law? You're not asking the best question. First, understand that many divorcing people see their spouses as narcissistic, because at the time of divorce they also tend to see the worst in everything about their spouses. Little personality quirks and foibles of a spouse are magnified in the eyes of some to help the other spouse feel better about themselves and about their arguments for divorce. So before you set out to expose your spouse as a narcissist, be sure that it's true. Second, there are varying degrees of narcissism, some clinical, some not. Someone who is self-absorbed, egomaniacal, and manipulative may be irritating to live with and work with, but that alone isn't a sufficient basis to entitle a spouse to more or less alimony or more or less child custody or parent time, for example. The condition alone is not a sufficient reason alone to deny a parent of custody or parent time. If a parent has a flaw or handicap, it's not the handicap that's inherently the problem. The problem is whether that flaw or handicap has done you or the marital estate real damage, whether the flaw or handicap renders a parent unfit to exercise care and custody of the children. It's not the narcissistic personality disorder, or NPD, itself that is a problem. It's whether the NPD sufferer is behaving in a way that causes legally recognized and punishable harm to the spouse and/or children. See? The court doesn't know, or usually care, what it means when you subjectively say, "My spouse is a narcissist." But the court can understand and respond to objective, independently verifiable facts, such as, "Here is proof that my spouse gambles away the rent money, beats the kids and me, gets drunk and passes out while the kids play in the traffic, or lies to get away with breaking the law, physically injuring others, avoiding accountability and responsibility, or taking advantage of others." If your spouse is so narcissistic that he or she is doing you or the kids real harm, or putting you or the kids at risk of serious harm, then you must show the court, based upon independently verifiable proof, not just your word over that of your spouse, that the other spouse or parent has done wrong, is in the process of doing wrong, attempting to do wrong, or poses a serious danger of doing harm. Only when you can show the wrong first may the cause or the why or the how matter. With all that stated, I concede that some judges have an uncanny ability to see the worst in people, or the best in people when it's not really there, and to be duped. You would think they'd be especially attuned and on the lookout for liars and con men and con women, but that often is not the case. Don't let the court be charmed and taken in by lies, brown-nosing, or alarmism either. Don't let the court play favorites or come to hasty and biased conclusions. Call out the court if and when it puts subjective feelings over objective facts, or the lack thereof.